72 hours ago, 3 federal appellate judges sat behind that bench, looked the United States government dead in the face, and systematically dismantled the prosecution's entire sentencing framework in the Sean Combs case. And I need every single one of you to understand what just transpired inside that courtroom, because this is not hyperbole. This is not internet speculation. This is not some conspiracy channel stitching together breadcrumbs. What happened in that appellate hearing has the potential to unravel the entire foundation upon which Sean Combs was sentenced. The 3-judge panel did not simply raise concerns. They did not politely suggest that maybe the government overstepped. They interrogated the prosecution with ferocity that I have never witnessed in a federal appeals proceeding, and I have consumed hundreds of these oral arguments. The judges cornered the government attorney, forced concession after concession, exposed logical contradictions in the sentencing rationale, and left the prosecution fumbling through their own closing arguments from the original trial, trying to explain how they can have it both ways. And the implications of what was revealed in that hearing are seismic. Because if these judges follow through on trajectory, their questions suggest Sean Combs could walk out of that facility a free man, not on a technicality, not on some procedural loophole that the public can dismiss, on the fundamental constitutional principle that when a jury speaks, the government does not get to overwrite that verdict through the back door of sentencing guidelines. Strap in. This is going to be meticulous. It is going to be thorough. And by the time we reach the end of this, you're going to understand exactly why legal scholars across the country are whispering the same 4 words. Combs is coming home. Before we unpack what happened at the appellate hearing, we need to establish the architecture of how we arrived at this moment, because the context is everything. Without it, the significance of what those 3 judges communicated will fly over your head. Sean Combs stood trial for 8 weeks. 8 grueling, exhaustive, headline-dominating weeks, but the federal government brought the full weight of its prosecutorial machinery against one man. The centerpiece of their case was the RICO conspiracy charge, the racketeering charge that would paint Combs as a head of criminal enterprise. Alongside that, they leveled sex trafficking charges, painting a portrait of systematic coercion, exploitation, and abuse. These were the big guns. These were the charges that carried the devastating sentences. These were the counts that justified the pretrial detention, the media circus, and the government's narrative that Sean Combs was not merely a man who committed crimes, but a kingpin orchestrating a web of criminal activity. And what happened after 8 weeks of testimony, evidence, cross-examinations, expert witnesses, and jury deliberations? The jury acquitted him on the RICO conspiracy, acquitted on the sex trafficking charges, acquitted the 12 citizens who sat through every minute of that trial, who heard every witness, who reviewed every piece of evidence the government presented, returned and said, "We do not find this man guilty of racketeering. We do not find this man guilty of sex trafficking." That verdict was not ambiguous. That verdict was not a hung jury where they could not decide. They decided. They weighed the evidence. They applied the law as instructed, and they rendered a definitive judgment. Not guilty on the most serious charges the government brought. What they did convict on were 2 counts of Mann Act violations. The Mann Act, for those unfamiliar, involves the interstate transportation of individuals for purposes of prostitution or unlawful sexual activity. These were specific, narrow charges tied to particular incidents. They were not the RICO. They were not the trafficking. In the government's own presentation, in their own closing arguments to the jury, the Mann Act charges were framed around commercial sex workers traveling across state lines. That was a theory. That was what they asked the jury to convict on. And the jury said yes to those 2 counts. Here is where the entire situation detonates. When it came time for sentencing, Judge Subramanian did not sentence Sean Combs based on the crimes the jury actually convicted him of. Judge Subramanian reached back into the evidence that surrounded the charges the jury rejected, the RICO, the sex trafficking, the coercion allegations, and used that acquitted conduct to dramatically inflate the sentence. He imposed a sentence that reflected the severity of a sex trafficking conviction, not the Mann Act violations the jury actually found. He treated the acquitted conduct as though the jury had simply not gotten around convicting on those charges, as though their not guilty verdicts were merely procedural inconveniences rather than definitive legal pronouncements. And that, right there, is the nuclear core of this appeal. That is a question the 3-judge panel spent a hearing interrogating with surgical precision. Can the government lose in front of a jury and then win through the sentencing judge? Can acquitted conduct that 12 jurors specifically declined to find proven beyond a reasonable doubt, be recycled by a judge who only needs to find it by a preponderance of the evidence, a dramatically lower standard, and then used to multiply the punishment? Because if the answer is yes, then what exactly is the point of jury trial? What is the point of the Sixth Amendment? What is the point of 12 citizens sacrificing weeks of their lives to deliberate if a single judge can functionally override their conclusions at sentencing? Those are not my questions. Those are the questions the appellate judges posed to the government attorney standing at that podium. And the government did not have satisfactory answers. Let me walk you through what unfolded in that courtroom, because the precision with which these judges dissected the prosecution's position was extraordinary. The first thing that became immediately apparent when the hearing commenced was the panel's focus. From the opening moments, the judges zeroed in on a specific discrepancy. The government prosecuted this case as a RICO and sex trafficking case. That was the engine. That was the narrative. That was where all the testimony about coercion, about violence, about control, about the so-called freak-offs lived. The Mann Act charges were, as one judge characterized them and the government eventually conceded, a sideshow. The word sideshow was actually used in that courtroom. One of the judges stated plainly, the Mann Act was an afterthought in the government's prosecution, and the government attorney did not vigorously contest that characterization because it was accurate. The Mann Act charges received minimal independent attention during the trial. The government did not present dedicated live witness testimony specifically for the Mann Act counts. Instead, they pointed to charts. They gestured at evidence that had been introduced in the context of the RICO and trafficking charges and said, look at these charts. These apply to the Mann Act too. And then in their closing argument, when they broke down each count for the jury, they described the Mann Act charges as being about commercial sex workers traveling across state lines, not about Cassie Ventura being coerced, not about any specific woman being transported against her will. The theory, as stated in the government's own summation, was about escorts being caused to travel. This matters enormously because of what Judge Subramanian did at sentencing. He took the coercion evidence, the violence evidence, the control evidence, all the material that undergirded the charges the jury rejected, and applied it to enhance the Mann Act sentence under the federal sentencing guidelines. He used a coercion enhancement. He found, by a preponderance of the evidence, that the conduct underlying the Mann Act offenses was coercive in nature. But the jury had already spoken on the coercion question. The jury acquitted on the sex trafficking charges, which required findings of force, fraud, or coercion. The jury acquitted on the RICO conspiracy, which encompassed the pattern of coercive behavior the government alleged. Those acquittals were, by their nature, a determination that the government had not proven coercion beyond a reasonable doubt. And then the sentencing judge turned around and found coercion by a lower standard and sentenced accordingly. The appellate panel was not subtle about their concerns with this framework. Judge Nardini posed a hypothetical that illuminated the absurdity with devastating clarity. He constructed a scenario involving a defendant charged with both first-degree and second-degree murder. The defendant shoots someone at point-blank range. The jury acquits on first-degree murder, which requires premeditation, but convicts on second-degree murder, perhaps finding it was a heat-of-the-moment act. The raw facts, pointing the gun, pulling the trigger, killing the victim, those are undeniable. Those underlie the second-degree conviction. But the jury specifically did not find premeditation. They looked at the evidence and said, we cannot conclude beyond a reasonable doubt that this was planned. Judge Nardini then asked the government attorney, under your theory, could a sentencing judge take those same raw facts, draw the inference of premeditation by a preponderance of the evidence, and then sentence the defendant as though they had been convicted of first-degree murder? Could the judge effectively impose a first-degree murder sentence after the jury acquitted on first-degree murder simply because the underlying facts were before the jury on the second-degree count? And the government attorney said yes. The government attorney stood at that podium and conceded that under their theory, the answer is yes. The sentencing judge could find premeditation by preponderance and sentence accordingly. The judge could give the death penalty equivalent after the jury specifically rejected the charge that would have warranted it. Let that settle. Let that actually penetrate. The federal government argued in open court before 3 appellate judges that a jury's acquittal on the more serious charge does not prevent a sentencing judge from functionally treating the defendant as though they were convicted of that more serious charge. The government's position is that the jury's verdict is a ceiling for conviction, but not a ceiling for punishment. And the judges heard that. They heard that concession. And the line of questioning that followed made it crystal clear that they found that position deeply troubling. Judge Baker hammered on the government's own closing arguments. She went back to the transcript and read the government's words back to them. On count 3, the Mann Act charge related to Cassie Ventura, the government told the jury, all of the examples I just went over show the defendant caused commercial sex workers to travel across state lines for freak-offs. The defendant is guilty of count 3 based on any single one of these instances. That was the government's theory. Commercial sex workers traveling. Not Cassie being coerced. Not Cassie being transported against her will. Escorts traveling. And then the government said, let us move to count 5. A clean pivot from one Mann Act count to the other. No mention of coercion in the closing argument's treatment of these counts. No argument that the Mann Act convictions should encompass the coercive conduct. That was reserved for the RICO. That was reserved for the sex trafficking. And the jury rejected those frameworks. Judge Baker pressed the government attorney. Why should we not hold you to the theory you presented to the jury? You told the jury this is what count 3 is about. You told them this is what count 5 is about. You defined the boundaries of those counts in your own summation. And then after the jury convicted on those counts as you defined them, you went to the sentencing judge and said, actually, these counts are much bigger than what we told the jury. Actually, all of that coercion evidence we presented under the RICO and trafficking umbrella, that applies here too, and the sentence should reflect that. The government attorney's response was, and I want you to absorb the inadequacy of this, that the closing argument did not represent the totality of the government's theory, that the jury was properly instructed on the elements of the Mann Act and had to find each element met beyond a reasonable doubt regardless of what the government emphasized in closing. In other words, the government's position was, ignore what we told the jury to focus on. Ignore how we framed these charges. The jury might have considered other things we did not argue. And Judge Baker was not having it. She pointed out that the jury listens very intently to closing arguments, that the summation is a critically important component of the jury's deliberation process, that when the government says, count 3 is about escorts traveling, the jury is going to deliberate on count 3 through that lens. And if the jury convicts on that basis, the government cannot then expand the scope of the conviction at sentencing to encompass conduct they never argued was part of that count. The government was asked directly, do you have the exact words of your closing? And the attorney said, I do not have the exact words, but Judge Baker did. She read them verbatim. The precision with which the appellate panel prepared for this hearing was formidable. They had the transcripts. They had the closing arguments word for word, and they used them like a scalpel. This brings us to what I believe is the most consequential exchange of the entire hearing. The judges were not merely questioning whether acquitted conduct could be considered at sentencing. Federal precedent does, in certain circumstances, permit judges to consider acquitted conduct at sentencing. That is established law. However controversial it may be, what the judges were probing was something far more specific and far more damaging to the government's position. They were asking whether the specific inference the sentencing judge drew, that the conduct was coercive, constituted acquitted conduct that could not be bootstrapped into the Mann Act sentence. Here is the nuance, and this is where the legal architecture gets intricate. The Mann Act does not require coercion. You can violate the Mann Act through voluntary conduct. Causing someone to travel across state lines for prostitution is sufficient. Coercion is not an element. So the jury could convict on the Mann Act without finding coercion. But the sex trafficking charges did require coercion. And the jury acquitted on sex trafficking, which means the jury declined to find coercion proven beyond a reasonable doubt. The sentencing judge then applied a coercion enhancement under the guidelines. He took the factual evidence that had been presented, the plain incident, the video shown to Cassie, the verbal confrontation, and drew the additional inference that this conduct was coercive. The appellate judges asked the government, that inference of coercion, is that not precisely what the jury rejected when they acquitted on sex trafficking? The raw facts may underlie the Mann Act conviction. Combs was on the plane. He showed the video. He said what he said. Those facts can support the Mann Act elements. But the additional conclusion that this was coercive, that he was forcing compliance through threats and intimidation, that is the very finding the jury declined to make. And the government tried to argue that the coercion was inextricably intertwined with the raw facts, that you could not separate the threatening language from the demand for the encounter that followed, that the threats were immediately followed by a demand for a freak-off, and therefore the coercive nature of the threats is directly relevant to establishing the intent element of the Mann Act. Judge Nardini cut through this with precision. He asked, what if the conversation on the plane had been different? What if instead of threats, Combs had said, when we get back, I'm going to fly in some escorts. You're going to have sex with them, and I'm going to pay them. No coercion, no threats, just a statement of intent. Would that establish the Mann Act elements? And the government said yes, that would establish the intent. So Judge Nardini's follow-up was devastating. If the non-coercive version establishes the Mann Act intent, then why does the coercive version add anything to the Mann Act analysis? Why is the coercion relevant to the Mann Act at all if the conduct did not need to be coercive to satisfy the Mann Act elements? And if the coercion adds nothing to the Mann Act conviction, then using it at sentencing is not using it to establish an element of the conviction. It is using acquitted conduct the jury rejected, to enhance a sentence beyond what the conviction alone would warrant. That exchange is the fulcrum of this entire appeal. That is the moment where the government's framework buckled under the weight of its own logic. Because the government needed the coercion to be part of the Mann Act story to justify the sentencing enhancement. But the coercion was the heart of the sex trafficking case. And the jury said no to sex trafficking. The government was trying to thread a needle that does not exist, arguing simultaneously that the coercion proves the Mann Act intent, while also being a distinct factual finding that the jury rejected. You cannot have it both ways. Either the coercion is relevant to the Mann Act, in which case it should have been argued as part of the Mann Act case, and the jury's acquittal on sex trafficking does not directly address it, or the coercion is separate from the Mann Act elements, in which case using it at sentencing is using acquitted conduct to inflate punishment. The government chose a second path at trial by not arguing coercion as part of the Mann Act counts, and then tried to switch to the first path at sentencing. And the appellate panel caught them in that contradiction. What makes this even more devastating for the government is the broader principle at stake. The judges were clearly animated by the fundamental fairness question. One of them articulated it plainly. What is the point of the jury system if the judge can take what the jury rejected and build a sentence around it? What message does that send to the next jury? What message does that send to the next defendant who goes to trial believing that an acquittal means something? If you can be acquitted of the serious charges and then sentenced as though you were convicted of them, the acquittal is meaningless. It is a performance. It is theatrical. And the entire jury trial becomes an elaborate ceremony that has no binding effect on the punishment the government can ultimately impose. This is not a fringe position. This is not some defense attorney fantasy. The Supreme Court itself has expressed discomfort with the use of acquitted conduct at sentencing. Justice Sotomayor has written critically about it. Justice Gorsuch has raised concerns. The practice has survived constitutional challenges, but it has survived narrowly and with significant judicial skepticism. And in this specific case, the appellate panel appears to be drawing a line. They appear to be saying, even if acquitted conduct can be considered in some circumstances, it cannot be used in a way that effectively converts an acquittal into a conviction for sentencing purposes. There has to be a boundary, and Judge Subramanian crossed it. Let me now address the sentencing itself, because the numbers tell a story that the legal arguments alone cannot fully capture. Sean Combs was convicted of 2 Mann Act violations under the federal sentencing guidelines, without any enhancements, without any consideration of acquitted conduct. Those convictions would typically result in a sentence that legal analysts have estimated to be significantly below what Judge Subramanian imposed. The enhancements that inflated the sentence, the coercion enhancement, the aggravated conduct findings, those were the bridge that carried the sentence from Mann Act territory into sex trafficking territory. Without those enhancements, the sentencing range collapses. The mathematical gap between what the Mann Act convictions warranted and what Judge Subramanian imposed is a precise measure of how much acquitted conduct influenced the punishment. And here's the part that makes this even more pointed. Sean Combs had already served nearly a year in pretrial detention before sentencing. He was held without bail for an extended period, and that time was credited against his sentence. So the actual additional time imposed, above and beyond what it already served, was built almost entirely on enhanced guidelines calculation. Remove the enhancements. Apply the base offense level for the Mann Act convictions. Credit the time served. And the arithmetic becomes very difficult for government, because the sentence that remains, stripped of the acquitted conduct enhancements, may well be a sentence that has already been substantially served. That is why the legal commentary following this hearing has been so emphatic. Multiple appellate attorneys, former federal prosecutors, and legal scholars who monitor the oral arguments have independently arrived at the same assessment. The appellate panel is signaling, through the nature and intensity of their questioning, that they believe the sentencing was flawed. The judges did not merely poke holes. They did not raise general concerns and move on. They constructed a systematic deconstruction of the government's sentencing rationale, built hypothetical after hypothetical that exposed the logical contradictions, and forced the government into concessions that undermine its own position. The government conceded that the Mann Act was a sideshow. The government conceded that their closing argument defined the Mann Act counts as being about escort travel, not coercion. The government conceded that under their theory, a sentencing judge could find premeditation after a jury acquitted on first-degree murder and sentence accordingly. Those concessions are devastating. Those are not minor admissions. Those are structural failures in the government's appellate position that give the panel everything it needs to vacate the sentence. And to be clear about what vacating the sentence means, It does not automatically mean Sean Combs walks free tomorrow. If the appellate court vacates the sentence, the case would typically be remanded back to the district court for resentencing under corrected guidelines. But if the corrected guidelines, stripped of the acquitted conduct enhancements, produce a range that has already been served or nearly served, then the practical effect is release. The court could also impose a new sentence within the corrected range, and that sentence could be time served or very close to it. There's also the possibility, though perhaps less likely, that the appellate court would go further and address the sufficiency of the evidence on the Mann Act convictions themselves. The defense has raised challenges on those grounds as well. If the court were to find the evidence insufficient, the convictions could be overturned entirely. That would be a complete vindication, a total reversal. It is a steeper hill to climb because the evidence regarding escort travel was substantial and largely uncontested. But the defense has raised arguments about the specific elements and whether the government proved them as to each count. That remains a live issue on appeal. Regardless of which path the appellate court takes, the direction of travel after this hearing is unmistakable. The panel was not performing neutrality. Their questions were not evenly distributed between prosecution and defense concerns. The overwhelming weight of the judicial scrutiny fell on the government's position, and the government buckled repeatedly under that scrutiny. Defense counsel, by contrast, faced relatively fewer and less hostile questions, which in appellate practice is a meaningful signal. When judges spend the majority of their limited hearing time pressing one side, it typically indicates where their concerns lie. Now I want to address something that extends beyond the legal mechanics because there's a broader cultural and systemic dimension to what transpired in that courtroom. The Diddy case was one of the most heavily publicized federal prosecutions in recent memory. The pre-trial coverage was saturating. The allegations were incendiary. The court of public opinion rendered its verdict long before the jury did. And when the government secured the Mann Act convictions, despite acquittals on the far more serious charges, the narrative became, justice was served, the system worked, the predator was held accountable. But what this appellate hearing revealed is that the system may not have worked at all. The system may have been bent. A jury did its job. 12 citizens heard the evidence and said, "We are not convinced of racketeering. We are not convinced of sex trafficking." And then a single judge looked at that verdict and said, "I am going to sentence this man as though the jury had convicted on those charges, because I personally believe, by a lower standard of proof, that the conduct occurred." That is not justice. That is a single judicial officer substituting their judgment for the collective judgment of the jury. And regardless of how you feel about Sean Combs, regardless of what you believe he did or did not do, that precedent is terrifying, because it does not only apply to famous defendants with resources to mount federal appeals. It applies to every defendant in the federal system. It applies to the person who cannot afford a top appellate team. It applies to the person whose acquittals are functionally erased at sentencing by a judge who simply disagrees with the jury. The appellate judges understood this. Their hypotheticals were not abstract academic exercises. They were designed to illustrate how the government's position, taken to its logical conclusion, eviscerates the jury trial right. If a judge can find premeditation after the jury acquitted on first-degree murder, then no acquittal is safe. If a judge can find coercion after the jury acquitted on sex trafficking, then no acquittal means what it says. And if acquittals do not mean what they say, then jury trials are not trials at all. They are preliminary hearings that generate a minimum floor conviction, and the real sentencing determination is made unilaterally by the judge based on whatever the judge personally believes. That is an unacceptable framework. And based on the tenor of this hearing, at least some of these appellate judges agree. For those keeping score at home, there are several possible outcomes when the appellate court issues its decision, and each carries different implications. The first and most favorable outcome for Combs would be a vacatur of the sentence with remand for resentencing under corrected guidelines, combined with direction from the appellate court that the acquitted conduct cannot be used to enhance the sentence. If the corrected guidelines range approaches or falls below the time already served, the practical result is release. The second possibility is a vacatur with remand but without strict direction on the acquitted conduct question, leaving some discretion to the resentencing judge. This would likely result in a reduced sentence, but perhaps not immediate release. The third possibility, less favorable, is that the appellate court affirms the sentence, finding that the sentencing judge acted within permissible bounds. Based on the hearing, this outcome appears least likely, but appellate predictions are inherently uncertain. There is also the question of what happens procedurally between now and the decision. The appellate court does not issue decisions immediately after oral arguments. There will be a period of deliberation, drafting, and potentially internal negotiation among the panel members. This could take weeks or months. During that time, Combs remains incarcerated under the current sentence unless a successful motion for release pending appeal is filed and granted. Given the signals in the hearing, the defense may be in a stronger position to seek such release, but it is not guaranteed. What I find most compelling about the hearing is not any single exchange, though several were extraordinary. It is the cumulative weight. The appellate panel did not identify one flaw in the government's position. They identified a cascade of flaws. The government presented the Mann Act as a sideshow and then used it as a vehicle for a sentence that reflected the charges it lost on. The government told the jury the Mann Act was about escort travel and then told the sentencing judge it was about coercion. The government argued that jury acquittals do not constrain sentencing judges, even when the sentencing enhancement is built on the exact conduct the jury acquitted on. Each of these is independently problematic. Together, they form a pattern that the appellate court cannot ignore. And beyond the legal architecture, there is a human dimension that I think matters. We talk about these cases in terms of guidelines and enhancements and preponderance standards. We use legal jargon that sanitizes what is actually happening. What is actually happening is that a man is in a cell. He has been in that cell for approaching a year. He was convicted of 2 counts that, standing alone, would not justify the time he has already served at the level the sentence was imposed. The additional years were added based on conduct that 12 jurors, the constitutional fact finders, said was not proven, regardless of the legal standard the sentencing judge applied, regardless of the technical permissibility under current precedent. There is a fundamental unfairness in punishing someone for crimes a jury said they did not commit. This is a point where I have to be transparent about my own perspective, because I believe in intellectual honesty above narrative convenience. I do not know what Sean Combs did or did not do behind closed doors. None of us do with certainty. What I know is what the legal system produced: acquittals on the most serious charges and convictions on the narrower ones. I know that the sentencing judge imposed a punishment that dramatically exceeded what the convictions alone would have warranted. I know that 3 appellate judges spent the better part of an hour telling the government, through their questions, that this framework has serious constitutional problems. And I know that the government's responses were inadequate, contradictory, and at times incoherent. I am not here to declare Sean Combs innocent of all wrongdoing. The Mann Act convictions stand unless overturned on appeal. The jury found that escorts traveled across state lines in his direction for unlawful purposes, and that finding has not been disturbed. But the difference between the Mann Act convictions and the sentence imposed is a chasm. And that chasm was filled with acquitted conduct that the jury rejected. And 3 appellate judges just spent a hearing telling the government that the chasm was improperly filled. For the legal scholars and courtroom observers who have followed this case from indictment through trial through sentencing, and now through appeal, the trajectory is clear. Something went wrong at sentencing. Judge Subramanian allowed the emotion and gravity of the broader allegations to influence a sentence that should have been tethered to the actual convictions. The government, emboldened by the public narrative and the severity of the allegations, pushed for a sentence that reflected the case they wanted to win, not the case they actually won. And the appellate court appears ready to correct that overreach. The government attorney tried to argue that much of the conduct the sentencing judge relied upon was admitted conduct, not acquitted conduct. That Combs himself had acknowledged certain behaviors, and there is some truth to that. There were admissions regarding the nature of the encounters, the role of escorts, and other factual matters. But the distinction the appellate panel was drawing was not about the raw facts. It was about the inferences drawn from those facts. The raw fact that Combs showed Cassie a video on the plane is not disputed. But the inference that this act was coercive, designed to compel compliance through fear and intimidation, that is the inference the jury rejected when acquitted on sex trafficking. And that is the inference the sentencing judge adopted when he applied the coercion enhancement. The government tried one more approach. They argued that the threats and the demand for the encounter that followed were so temporally proximate, so closely linked in sequence, that the coercive nature of the threats was inherently relevant to establishing the intent element of the Mann Act. Threats followed by a demand for a freak-off, they argued, demonstrate the defendant's intent to engage in the unlawful activity. But Judge Nardini demolished this with his hypothetical about the non-coercive alternative. If a simple statement of intent without any threats would have been sufficient to establish Mann Act intent, then the coercive dimension adds nothing to the Mann Act analysis. It is surplus. It is an overlay from the sex trafficking case that does not belong in the Mann Act framework. And using its sentencing to enhance the punishment is converting acquitted sex trafficking conduct into Mann Act consequences. The government had no effective rebuttal. The attorney paused, hedged, acknowledged the logical force of the hypothetical, and ultimately retreated to the position that the sentencing guidelines permitted the judge to consider the conduct regardless. which is essentially saying, we do not have a good answer for why this is fair, but the rules technically allow it. That is not a winning argument before a panel that is clearly concerned with fairness. I want to close by returning to where we started, because the implications of this hearing extend far beyond one case. The Sean Combs appeal is, in many ways, a referendum on the use of acquitted conduct in federal sentencing. It is a test case for whether appellate courts will continue to permit the practice in its most aggressive form, or whether they will begin to impose meaningful limitations. The Supreme Court has been inching toward this question for years. Several justices have signaled their willingness to reconsider the constitutional foundations of acquitted conduct sentencing. And if the Second Circuit, one of the most prestigious and influential federal appellate courts in the country, issues a strong opinion limiting or condemning the practice in this case, it could accelerate the Supreme Court's consideration of the issue. That means what happened in that courtroom is bigger than Diddy. It is bigger than celebrity. It is bigger than entertainment law gossip. This is a constitutional inflection point. The question of whether a jury's acquittal has binding force at sentencing or whether it can be circumvented by a judge's independent finding is one of the most important unresolved questions in federal criminal law. In this case, with its high profile, its clear factual record, and its stark contrast between jury verdicts and judicial sentencing, is potentially the vehicle through which that question gets definitively answered. 3 judges sat behind that bench. They heard the government's best arguments. They found those arguments wanting. They asked questions that exposed fundamental contradictions. They forced concessions that undermined the sentencing rationale. And they signaled, as clearly as appellate judges ever signal anything, that the sentence as imposed presents serious problems. We are in a holding pattern now, waiting for the written decision. But the oral arguments left little doubt about the direction of the wind. The prosecution built its case on the RICO and the trafficking charges. The jury rejected those charges. The prosecution then tried to smuggle the rejected charges into the sentencing through the back door. And the appellate court just told them, we see what you did, and we do not find it acceptable. The implications are profound. If the sentence is vacated and the corrected guidelines range reflects only the Mann Act convictions without the acquitted conduct enhancements, Sean Combs may have already served the bulk, if not all, of his adjusted sentence. The man who was sentenced as a sex trafficker despite being acquitted of sex trafficking could be resentenced as what the jury actually convicted him of, a Mann Act violator whose conduct, while criminal, does not warrant the years that were stacked onto his sentence based on crimes the jury said he did not commit. For those who supported the prosecution and believed the jury got it wrong on the RICO and trafficking charges, this is an uncomfortable conclusion, but the discomfort is the point. The jury system does not exist to ratify our feelings. It exists to protect individual liberty against government overreach. It exists to ensure that no person is punished for a crime unless 12 citizens unanimously agree, beyond a reasonable doubt, that the crime was committed. When we allow judges to circumvent that protection at sentencing, we are not strengthening the justice system. We are hollowing it out. We are keeping the facade of jury trials while stripping them of their binding force. The 3 appellate judges who presided over this hearing understood that. Their questions were not merely about Sean Combs. Their questions were about the integrity of the federal criminal justice system itself. And based on those questions, based on the government's faltering responses, based on the concessions that were extracted and the hypotheticals that went unanswered, the conclusion is inescapable. The sentencing in this case is in serious jeopardy. Whether Sean Combs ultimately walks free or receives a significantly reduced sentence, the hearing itself has already accomplished something historic. It has placed the practice of acquitted conduct sentencing under an appellate microscope in a case the entire country is watching. It has demonstrated in real time how the practice operates. A jury acquits, a judge disagrees, and the defendant pays a price for crimes the jury said were not proven. And it has given the appellate court an opportunity to say, unambiguously, that this is not how the system is supposed to work. The ramifications will reverberate through every federal courthouse in the Second Circuit and potentially beyond. Defense attorneys will cite this hearing. Prosecutors will recalibrate their sentencing recommendations. Judges will think twice before using acquitted conduct to dramatically inflate sentences. And the conversation about acquitted conduct sentencing, which has been building momentum in legal academia and in the Supreme Court's own dicta for years, will accelerate. Something shifted in that courtroom. The ground beneath the government's position fractured. And when the written opinion arrives, we may look back at this hearing as the moment the fracture became irreversible. Stay close to this. Pin this. Bookmark this. Because a decision will come, and it is going to ride with the force of a judicial earthquake. And when it does, the legal landscape of federal sentencing will not be the same. Not in the Second Circuit. Not anywhere. That is the full picture. not filtered through bias, not sensationalized beyond what the record supports, not trimmed to fit a narrative. The appellate hearing spoke for itself. 3 judges interrogated the government with the intensity reserved for positions the court finds untenable. The government conceded points it should never have conceded. The defense left the courtroom with the wind unmistakably at its back. And the sentence that Sean Combs is currently serving, the sentence that was built on the back of acquitted conduct, is teetering on the edge of collapse. What comes next will determine whether the system corrects itself or whether the precedent of punishing people for acquitted crimes is allowed to calcify into permanent practice. For Sean Combs personally, the stakes are years of his life. For the federal criminal justice system broadly, the stakes are even higher. This is about whether jury verdicts mean what they say. This is about whether acquittal carries force or whether it is merely a suggestion that a sentencing judge can override. 3 judges heard the arguments. The arguments were devastating for the prosecution, and the legal world is waiting with considerable anticipation for the opinion that will follow, because what those 3 judges decide will not just determine whether one man goes home. It will determine how much power a jury truly has in the federal system and whether the promise of the 6th Amendment, the right to trial by jury, retains its meaning in an era where sentencing judges can reach past a verdict to impose punishment the jury never authorized. The hearing is over. The arguments are on the record. The concessions have been made. And the weight of every legal principle the appellate panel invoked during the hearing tilts in one direction. It tilts toward a finding that the sentencing was constitutionally infirm. It tilts toward vacator. It tilts toward a resentencing that reflects the crime Sean Combs was actually convicted of, not the crimes the jury said he did not commit. We will see. But the signals from that courtroom could not have been clearer. And if you have been paying attention, truly paying attention to what those judges said and what the government failed to adequately answer, the conclusion writes itself. This is not wishful thinking. This is appellate analysis based on a hearing that is on the public record. Go listen to it yourself. Hear the judges' questions. Hear the government's halting responses. Hear the concessions. And then ask yourself whether a sentence built on that foundation can survive appellate review. I do not believe it can. And based on what happened in that courtroom, I do not believe those 3 judges believe it can either. The decision is coming. And when it arrives, it will either affirm that jury verdicts are sacred and that sentencing judges cannot erase acquittals to the back door, or it will confirm that in the federal system, your acquittal is only as strong as your sentencing judge's willingness to respect it. For the integrity of the system, for every defendant who will stand trial after this one. And yes, for Sean Combs himself, the answer needs to be the former. The courtroom has spoken. The appellate panel has shown its hand. The government is on its heels. And the next chapter of this case, the written opinion, will determine whether justice is ultimately served or whether the sentence that was built on the wreckage of rejected charges is allowed to stand. Every indication from that hearing says it will not stand. Every signal says the sentence is fatally flawed. Every concession the government made weakened its position further. And when the opinion drops, I will be here, breaking it down line by line, word by word, provision by provision, so you understand exactly what it means, exactly what it changes, and exactly what comes next for Sean Combs and for every defendant who follows in procedural footsteps to the federal system. Because this story is far from finished, not by a considerable distance. The hearing was just the overture, the opening bars of composition that will reshape how we think about federal sentencing power. The decision is the movement that matters. And if the appellate court follows the logic of its own questions to their natural conclusion, Sean Combs will not be serving that sentence much longer. That is not advocacy. That is not cheerleading for any outcome. That is appellate reality grounded in the transcript, the concessions, and the unmistakable trajectory of the panel's interrogation. And the courtroom record, every syllable of it, supports every single word I have laid before you today.